Good evening. Thank you for joining us on the People's Court, and with the powers temporarily vested in me, I wish to declare the People's Court in session. Karibuni sana. We're coming to you live from the Moot Court at the Mount Kenya University Parklands campus. This is where the law school of the Mount Kenya University is. And we are joined by an eminent panel of experts of different insights and different perspectives here to help us shed some light on the subject matter at hand. With me is, as always, George Maringa and Linda Alela. Over to you, George.
Absolutely. And tonight we have several issues to discuss, but we've summed them up into three main subject areas. We shall be looking at the tiff between the executive and the judiciary. We shall also be looking at the recent meeting between the president and the Chief Justice, as well as the role of LSK, looking as well as the upcoming LSK elections. We thank you for joining us. Once again, my name is George Maringa. Tonight, the contestants are vying for the president of LSK that are joining us is Faith Othiambo. She is the vice president of the Law Society of Kenya. Thank you so much, Faith, for joining us. As well as Xavier Akabi, joining us, of course, is Xavier Akabi, also a general member, a representative of the Law Society of Kenya, vying for the president position as well. General member, of course, I'm corrected, general member, representative of the LSK. These are the candidates joining us tonight. It is important to mention at this point that we had invited all candidates vying especially for the LSK president position, but those that are in session right here at the Moot Court are the ones that have been able to join us. It was an open invitation. Linda Lela, whom do you have?
And on the end of the panelists, because it's also important that we get their view. And remember, beyond the LSK elections, we look at the bigger umbrella of just how does the legal aspect play out in ascertaining the rule of law. And therefore, we have legal minds that are joining us this morning. Francis Wanjiku, who is the head of public policy, IC Law, LLP. Thank you so much for creating time, as well as Ndong Evans. And Ndong Evans is a constitutional law expert. Thank you so much, as well as another legal mind that joins us this evening in the name of Peter Wanyama. Thank you so much as well for joining us, gentlemen, for this great session that we have. Whom do we have on your end, Victor Moyakani?
Right, on my end, and of course, as all of you can see, we've got an eminent panel, as we called them a little bit earlier on, and I'd like to kindly introduce our host this evening. If we haven't already, our host is actually the Mount Kenya University School of Law at Parklands campus, and with us is the head of that law school, the dean, if I am not mistaken. Karibu sana, sir. Is it Doctor or is it Professor Mutubwa?
Dr. Mutubwa.
Dr. Mutubwa. Karibu sana. Thank you for having us.
You're welcome.
I'm sure you're having very strange faces to this moot court.
We are happy to host you. We are very excited to see all these new faces.
Brilliant.
Yes, thank you.
And I certainly hope you'll teach us a thing or two.
We also certainly hope to learn from you.
Right.
Because this is a moot court. This is where we learn the practical skills of advocacy, and we hope to learn from the very eminent colleagues who have joined us this evening.
Right.
Yeah.
And indeed, in the audience, we actually have some of your students,
yes.
Doctor.
Yes.
Some of your students are in the audience, and this is word for you who are watching us right now live in the studio, and those who are watching us from home. I hope you look at the gentleman and lady that are in front of you this evening, and I hope you're inspired. I hope you're fired up. But more importantly, I hope you learn something that will help you serve your nation a little better. I hope I have your agreement on that. Thank you very much. Thank you very much. Had we introduced all of them?
Yes, we have introduced all of them, and at this very point, it's just that the audience cannot say anything, but they can as well wave and tell us that we're all steamed up for this very important conversation. At least with our legal minds, they don't get to wave. It's a serious session, and therefore you might not expect for them to be all excited and all that. So where do we kickstart from, Victor?
Right. So here's how we're going to do it. First, we know what's been going on across the country. There's been a lot of conversations and debates around the relationship between the executive and the judiciary. this is something we wish to focus a little bit of attention on. And this, of course, follows weeks of what looked like wrangling between, again, the judiciary and the executive. So, George,
yes,
what I'd like you to do is, tap into the wisdom and insight of our eminent panel over here. Let's just get a round of insights into, or maybe takes, from where we sit, what exactly has been happening, in the country. We'll start with you, Mr. Xavier. Could you please tell us, from where you sit, what do you think has been happening? What's been your take on, the state of the nation as far as the executive and the judiciary is concerned?
You'll be able to come here? Yes.
So thank you very much for that question. And personally, I think that what has been happening in this country is the executive trying to encroach into the avenue or into the road or into the path of the judiciary. We've seen the president making statements which can be perceived to be encroaching or trying to, influence what judges, what the judiciary has to say about certain cases which are happening, which are ongoing in this country. And of course, as legal practitioners, that is something which we know is unconstitutional, because in Kenya we have a constitution which was promulgated by the people of Kenya, and which creates a system of separation of powers where we have these three arms of government working collaboratively, but they cannot encroach into the functions of other systems of government, if I can say that.
Right.
Now, when you have a person like the President of the Republic of Kenya, who ought to know better, a very good, very staunch politician who's the head of state, and who's saying that the judiciary is the judges, or casting aspersions on judges, that they are corrupt, or that the decisions that they are making are sort of influenced by corruption or influenced by third parties, then the president ought to bring evidence to show that what they are doing is actually corruption. But what we are seeing right now is a platitude, just a statement by the president, but nothing to back it up.
All right.
Yes.
All right, fair enough. We shall get back to you in a moment. Of course, good people who are watching us, Mr. Xavier Ahabi is General Member Representative of the Law Society of Kenya. George, I believe you have a constitutional law expert on your hands.
I do have a constitutional law expert that will be handled by Linda, but in the meantime, just to throw the question on this same that we've been seeing, I'd like to invite Faith Ofiembo, the current Vice President of the Law Society of Kenya, to be able to pick your minds, and perhaps you can address that issue. And as you look in a spectrum, was the conversation, the dialogue between the President and the Chief Justice something that, as a legal expert and also as a lawyer and the Vice President of the Law Society of Kenya, you wanted and you had envisioned?
Well, let's just start from where is this discussion headed, or where did it come from? Now, the head of state has the right to sit with Parliament, the Speaker of the Senate, and the National Assembly, as well as the Attorney General and the Chief Justice, to come and discuss issues affecting the three arms of government. So without a doubt, that's their right to sit and discuss the same. But we say, what is the backdrop of this discussion? Now, the Law Society has come out strongly castigating the scathing remarks that the head of state made at a roadside construction when he's saying that the judiciary is corrupt, at the backdrop when the next day the Court of Appeal was hearing the appeal that had been filed by the government against the decision of the High Court. Now, and part and parcel of what is dear and near, I would say, to the president, part of his development agenda, is the housing levy. Now, this issue, that statement comes at that backdrop. The head of state makes those remarks. The judiciary, then we see Martha coming out with the rest of the commissioners, coming out to strongly condemn the same. The Law Society, we go on the streets to support the rule of law, and we want an independent judiciary. Then what do we have? The head of the judiciary comes out and she says that she's calling for dialogue. What are you going to dialogue about? Are you going to dialogue about corruption? Are you going to dialogue about the scathing remarks that has been made by the head of state, who has a responsibility as a leader that members of the society are looking up to? And without a doubt, we cannot overlook the fact that as the head of state, he carries quite a number of constituents behind him. They believe in him, they trust in him. The court affirmed the decision that he won this election. And at that backdrop, it means a majority of the people of Kenya believe in him, trusted in him, and are behind him. So when he makes such remarks, and we are seeing the head of the judiciary saying, let's come and discuss those issues. If you're saying about corruption, isn't there a clear path on how to deal with corruption? Isn't the same Chief Justice the one who said that if the head of state is saying that there are elements of corrupt judicial officers, bring evidence and let us prosecute the same? The Law Society has also come out to say, in elements when we have corruption, let us deal with those corrupt judicial officers. Now, when we see thereafter the meeting, what comes out, the statement that comes out, there's a general discussion about the three arms of government going to fight corruption. There's a general statement that they will sit and have a task force and come up, the three of them will come up with a report to table to who? To be worked on by who? Yet the three arms of government are independent and they have mechanisms to deal with the same. Then we see promises coming out towards the judiciary. I say it in jest, but I have to say it. Now, whenever you give somebody a reward or I give you a sweet, there's an intention towards it. So what is the unsaid terms that is not in that statement?
Right, right. And on that note, very, very, very interesting and thought-provoking note, let's shift over to Linda. Linda, you've got a panel of experts on your hands.
And also an aspirant, and who I think after the break that we're going to have is going to shift to this other side. And perhaps the viewer could be wondering, why are some of these people having to, why do they have to stand? The few that will be standing on that bit are aspirants, and I mean, later on they'll be telling us what then their plans are for the LSK. But before then, Peter, if you could march into that other space, because Peter too is an aspirant for the presidency bit, and perhaps just answer to some of these concerns that have been raised, that the CJ, had ample time to make a decision on whether to stick to this position or her position to meet the president, because then upon that declaration, there was a day or two before then they met yesterday. And by this time, there were a lot of complaints or questions as to whether it was necessary for them to meet. But the two, alongside their teams, proceeded to meet. Was this in contempt of the voice of the people, in contempt of the position of a majority of the LSK members? Or what exactly does this set as a precedent?
Thank you very much. My quick reaction is that, one, there will be always tensions between the three arms of government. Political tensions spewed over by the executive to the judiciary. These three arms of, and of course the judiciary reacting. And sometimes you find that parliament also comes into the mix. These tensions are normal for the development of a democratic society. Let me emphasize that. They are normal. It's important that we see these tensions coming up, because then we are able to have a discussion which then sets basis for the development of rule of law and constitutionalism. The Chief Justice heads the Supreme Court. The Chief Justice is also the chairperson of the Judicial Service Commission. The Judicial Service Commission has a mandate under the Constitution to protect the independence of the judiciary and the independence of judges. The Chief Justice is also the Chief Justice of the Republic of Kenya, heading the institution of the judiciary. The President occupies an important position in our governance framework. Arguably one of the most powerful positions in terms of just responsibility in governance is held by the President. You have the Speaker of the National Assembly, the Speaker of the Senate. They occupy the legislative body. So these three arms of government are supposed to work for one purpose within the parameters set up in the Constitution. The judiciary's responsibility is to interpret the law. So if there's a dispute which any Kenyan has filed in court to challenge an executive decision, you expect the judiciary to come out boldly and apply the Constitution. The principles for interpreting the legal framework has been set up, and they're expected to apply that without fear or favor, because that's a constitutional demand. We expect that then the executive will not interfere with these functions, especially making a critique of a decision which they are not happy with. Because then the perception, and this is where the Chief Justice then may have gotten it wrong. You know, the court has issued an order which hamstrings an executive action. Then the President comes out publicly and issues a scathing statement against the judiciary, in a wholesale manner, condemning them as corrupt. So it then raises questions of perception whether the President really wants to control decisions which are made by the judiciary. And that is where the people of Kenya now are raising concerns. The people of Kenya are raising concerns and saying, Kenya is a democracy governed by the rule of law. Why is the President seen to be making those remarks? And then to make it worse, and that is why we fault the Chief Justice by immediately going to State House for a meeting after the President has made such a remark. And remember, after when the Chief Justice was issuing that press conference, she made a statement on the final actual reaction, where she said we need to dialogue. So that aspect of dialogue is what called into concern a lot of issues, especially from us as legal practitioners. What are you going to dialogue about?
All right, Peter. Let's hold it at that and engage the other two gentlemen. Evans, then do we say that the dispensation of justice is in limbo in this case? And not just because the two met alongside their teams, but basically also when we look at the Law Society and the legal members and the lawyers themselves, there's been a lot of complaints as to their aspect of integrity and as well ethical aspects. What do we look forward to when it comes to the dispensation of justice?
Yes, thank you so much, Linda. I think for me, I would begin by saying that there is nothing new from the statement we saw, the joint statement we saw from the President and the Chief Justice that we have not had. What should concern Kenyans is what was unspoken. We already have the National Committee of Administration of Justice, which of course brings this coordinated, efforts in terms of fighting corruption from all the justice sectors. So when the President releases a statement and tells us that they met with the Chief Justice and that in their meeting they agreed that each arms, should fight corruption within their mandate, that already is what the EACC Act tells us. That is already the call of Chapter 6. That is already the call of the Leadership and Integrity Act. So what Kenyans should be looking at is what is it that we were not told? Even before we talk about this issue of corruption in the judiciary. Because when you look at that statement, there are several issues that must concern legal practitioners in this country. One, that statement says that it was at the request of the judiciary. And I agree with my learned colleague, Faith, here, who said that indeed the backdrop is what needs to concern us. I see that the former president, Uhuru Kenyatta, learned very painful lessons from the Katiba 2010. And what we are seeing now, Linda, for without a doubt, are tantrums of a president that is yet to see the painful lessons of the 2010 Constitution. Because what would be the Chief Justice? And I said it from the beginning. It is the president who raised this issue that, there is corruption in the judiciary. We need to meet. We need to fight corruption. Already Article 166 gives us a mechanism of dealing with any gross misconduct, any corrupt, practices, bribery that has been over-mentioned in this process. Already there is a procedure. The other day, the deputy president comes out and say, names a judge publicly, tenders promises to tender evidence, tenders no evidence. And then another concern that should concern us, more importantly, is that such a critical meeting that goes to the core of the rule of law takes place at State House.
Okay.
So what should concern us, Linda, is not what we saw. It is what we did not see.
Oh, well,
and that is important. And that is
I want to take it away from you. I want to take it away from you quickly, because the question then would be, are we concerned enough? And in the event that we are concerned and we raise an alarm, just how much can we do to address the possible problems then that would crop up? Allow us to take a quick short break. Daktari will be coming to you shortly, as well as you, Wanjiko, shortly after this short break.
Wanasema wasemao kuwa elimu ni bahari haiishi kwa kuchotwa. Wakati mwingi natangamana na wanafunzi madarasani, sio kama mwalimu bali kama nahodha kwenye kipindi cha tasnia ya elimu. Na iwapo utanikosa madarasani, basi utanipata nyanjani nikisaka habari zenye usawa, ufasaha na ukweli. Na iwapo utanikosa nyanjani, bila shaka utanipata studioni, hapa nikisoma habari na kuendesha mijadala mikomavu. Mimi ni Andrin Kilemi, mpenzi wa lugha ya Kiswahili na elimu kwa jumla.
They say money makes the world go round. So let's slow things down a bit. Put things in perspective. From the markets to the streets to the stocks, we make the complex comprehensible. Join me, Hibak Said, on TV47 Business News for market insights like never before.
The news that matters the most is the one that hits close to home. When disasters strike, we are there to inform you. When the bullets are flying, we tell you who's shooting and why. Reporting on your victories, your health, your money, your security, your past, present, and future. We are interested in telling.
Good evening and welcome back to the People's Court. We are joining you live from the Mount Kenya University Parklands campus, which is where the School of Law is located. We are in court and the People's Court is in session. Linda, You were in the middle of a point with your guest here, Mr. Ndong, on a very, very critical subject, and you were about to introduce our host tonight, the Dean of the School of Law of the Mount Kenya University School of Law at Parklands. Take it away, please.
Well, President dictates that then the boss speaks last. Let's loop in Wanjiko first on this one. And basically, you know, what is playing out in the country, it worries the people, it worries the Law Society of Kenya, it worries those ones that are, you know, mandated to oversee just how justice then can be administered in the country. Is this perhaps something that speaks of a lacuna in law, and just how best do we address it?
Thank you, Linda. First, I want to clarify that I'm not vying for any position within the Law Society of Kenya.
That's clear.
Yes. I'm a member and a voter, and I hope this session will be able to bring out the good and the bad. So I'll ask your viewers one favor, that they should forget I campaigned and I voted for President William Ruto. Because this has become a very abusive relationship, and I think this is the time we cut the cord for me to be able to contribute to this topic. However, if you look at what has been happening, and I agree with my colleagues, and it's a very rare opportunity to find lawyers agreeing on a particular point. So if you look at what Chief Justice Martha Koome has done, this is what we call the handshake between the judiciary and the executive. The question that lawyers and the viewers and the students should be asking, what are the terms of this handshake? So the president was clear on his terms, that he wanted government projects to proceed. And we know that, one, the social health insurance fund had been stopped by the court. Suddenly it has resurrected. We knew that the Hustler Fund, not the Hustler Fund, this housing levy, it was on its deathbed. So now we are waiting on the 25th of this month. We are waiting to hear what the Court of Appeal will say. So the question is, has the Chief Justice promised to resurrect the housing levy? That is the question that every Kenyan will be watching on TV in the next coming days. But if at all the Chief Justice has sold Kenyans and has sold the judiciary, the question Kenyans should be asking is whether the next president of the Law Society is ready to fight this fight.
And I mean, why is it that there seems to be an already declared position of what could have been details of these conversations? Okay, while the details might be out, but you also are requesting that we get to know what is this that was not spoken about. Why do you ask for these details, yet you already have a position as to this matter that perhaps the judiciary or the CJ has already sold out the Kenyans?
So we have to understand it in the context that the meeting between the Chief Justice and the President was not a legal meeting. It was not a meeting of lawyers. It was not a meeting of minds. It was a political meeting. If
you listened to the Vice President, she declares, and we all understand very well, that all this that are arms of government are allowed to meet. There is nothing wrong. Perhaps the concern would be is that they are meeting at the backdrop of such complaints from the executive. Why would you want to argue that this is a political meeting, unlike a meeting that is legally allowed between the executive as well as the judiciary? It
is allowed. Even political meetings are allowed between the Chief Justice and the
declaration
President.
Your declaration is that this is a political
meeting.
All right.
What the problem is when the terms of reference are not clear, the Kenyans have a right to be suspicious.
Well,
yes.
Fair enough. Daktari.
Thank you very much. I am very intrigued by this discussion, and I'm sure my students are intrigued. When we teach students here, we teach them to be objective, to be consistent, and to be analytical. Yeah. The aspirants, the good counsel, my colleagues have spoken very eloquently about constitutional theory, the framework, and how we operate. I think what is important and what is emerging here is that tension, as Peter put it, between arms of government is important because they're supposed to check each other. But again, let's not look into these and say we veer into the realm of speculation. The beginning point is to say this. All these people who met yesterday, everybody exercises power on behalf of the people of Kenya. They earn from the government, pass from the taxes of the people out here. And they are mandated to act in specific functions, but to also check each other. So when you listen to the president, you may not agree with the diction, the choice of words, but he has a legitimate concern as a Kenyan, as a person who has been given the mandate by the people of Kenya to lead this great republic. The Chief Justice, and I want you to cut the Chief Justice some slack. She has earned her colors. This is a person who is known, particularly in the struggle for liberation. I do not think that I am prepared today to say that the Chief Justice is a sellout today. Because understanding the role of a leader, of an organization, of an institution that has to rely on other institutions to function. Remember, the people of Kenya in this constitution also said that organs of state shall be interdependent. What it means is that you will function, but recognize that you will have to function with other organs of state in an ecosystem that has been given to you by people of Kenya. So when I listen very carefully to this debate, I say sometimes that this is just too much ado about nothing. Because when the Chief Justice, the Speaker of the National Assembly meet and the President meet and they discuss matters of concern to the state, I did not hear them discuss a specific case. I did not hear any of them say that we are going to decide a case in a particular way. My colleagues have said, look, it is that which they have not said that you should be concerned about. That is speculation, because you are now making what is called deduction out of matters, because we as lawyers are evidence-based in terms of how we make decisions. And I'm not saying the president was right or wrong. He may have chosen the wrong words. But if you analyze, if you critically listen to what the president is saying, he has a concern. And what the Chief Justice was saying is that we hear you, but we have processes. So the middle ground struck yesterday is actually a beautiful thing in a democracy, in my view. Because look at it this way. When you have arms of government that do not speak to each other, that do not work in harmony, and you are here saying that we must have absolute tension and excise the severe completely the way these organs work, it is illogical. This concept of separation of powers, propounded by some French philosopher Montesquieu many years ago, it's something we teach students, it's something we talk about in constitutional theory, but in reality does not exist. On the ground, the reality is this, that when you...
Your students are laughing.
On the ground...
You better be ready.
The reality is this, that organs of state must coexist with respect to one another's mandate. If you have a particular reason to be concerned that the president is overreaching the executive powers into the judiciary, decisional independence of judicial officers, not even the Chief Justice can direct a judge or magistrate on how to decide on a particular case. And I think that is the point that has to be made. That is what must be jealously protected, not the relationship between state organs. And I want to say this as I finish. It is important for us to know that the independence of the judiciary is important. The rule of law is important. And I hear people speak about the rule of law, romanticizing that concept. Very good. But the rule of law does not exist in an abstract. The rule, in fact, if you ask me, there is nothing as a pure concept of the rule of law. What you have is a rule of law as interpreted by men. And these are the men and women who sit in the judiciary. The point being made here is this, that we are all held on the same standard. Even the president has to be held to that very high standard and ideal.
Right.
But we must also ask ourselves that where there is legitimate concern, where the judiciary has concern about the actions of the executive, it has powers in its judgment. Where the individual citizen has concern about the executive's power, he has the power of the ballot. Where the executive has concern about the functions of the judiciary, there are also processes which can be invoked. And when an individual in the leadership of the executive comes out to say, look, I also think that I have a problem in the manner in which this organization conducts itself in a general manner. Where is the difficulty in understanding that this is indeed what the Constitution wants us to have? A debate just like this one. Thank you.
I'll take it back to the judge.
So at this point, I think it's important, now that we have a lecturer in our midst, would you care to educate us and the general public exactly how a judiciary can be captured by an executive or by the executive? This is one of the things that has been expressed to be a fear, a concern of the talks that are happening right now. Talk to us, lead us down this path. How exactly can the judiciary be captured by the state? This worst case scenario that we're talking about.
The fear is a founded fear because we have lived through those times. Those of us who were there during the struggle of the second liberation, you have had stories of the president calling judges, decisions being made in favor of the state and asking the president what decision to make. I have not heard of those, at least not with empirical evidence in the past. But what the lawyers are saying is also fair. It's fair to also give credit where it's due. And that is the beauty that I see with our law society. Where there has been progress made by the state, the law society has supported. Where there has been faltering, we have also criticized. So the extreme notion where there is overreach by the executive to determine even the way cases are determined or how judges are appointed or who becomes a judge or who sits in a certain matter are matters we have lived through as a country. And we must always remember that that was a dark part in our history. But we must ask ourselves, is that the same thing that is playing out today? A president is standing up and venting his frustration is a good thing because it shows that the president also has difficulty penetrating this very independent institution. So it tells you that the fundamentals of a good judiciary are in place. They are intact. Otherwise, the president would have sacked the Chief Justice, sacked the judges in the olden regime. But today, he must find a way of addressing the Chief Justice as an equal in terms of heading an institutional arm of government. And I think it's a good thing because I think the Chief Justice knows that she has taken the oath of office to protect the Constitution and to protect the institution of the judiciary. I do not see a threat today, but it is important to remain vigilant. But as you asked, the question is, are we sliding back to those days? I do not think so. Does the 2010 Constitution insulate us from those possibilities, at least in the near future? Yes, and this is what we see as a very robust Constitution that makes it important for these two people to sit together to even discuss the administration of justice, because the president cannot do anything apart from complain and throw tantrums, as it has been said. But he's throwing a tantrum and saying, look, I have a job to do. I'm in the second term of the year. Can you tell me why I am not able to progress? That frustration is good because it tells you that the judiciary has also put its foot down.
Okay.
Yes.
All right. Thank you, sir.
Yes.
George, over to you.
Thank you very much. And of course, remember, at the backdrop of this conversation are presidential aspirants of the Law Society of Kenya. And I want to call upon Faith Othiambo to be able to tell us, in your administration, in your tenure as president of the Law Society of Kenya, should you be elected, what will you strive to achieve as harmony between the executive and the judiciary, as well as, notably so because you have a male representative to the JSC, but also looking at the adherence of the rule of law by the LSK?
Before I answer that question, allow me to say something based on what Mwalimu said. I being also a law lecturer at the School of Parkland.
Yes.
Now, I would like to say that as much as we may think we cannot get there or we are not closer to that direction, I would say look at the depiction of Troy. How did Troy happen? Destroy from within. So we are having the head of the judiciary coming out, and she's the one calling out that let us sit down, let us talk, let us resolve this issue. So once you instill fear from the top, what expectation do you have from the rest of the members of the judiciary? Because these same judges are relying on the chairperson of the Judicial Service Commission to stand up and fight for their independence. Now, when this head of the chairperson goes and runs to sit with the head of state, and I would say it's not really a tantrum, because if it's a tantrum, you let the child jump and scream, and you ignore them until they come back to you. But this is a situation when if it was a tantrum, the tantrum was thrown and the parent walked to the child. What happens? Has any lesson been learnt? In fact, you have taught the child that when you throw a tantrum, I will come to you. I will come to beg you not to do what you're doing. And so the habit or the behavior, there'll be no change. And I say something else is that there is still a legitimate concern, because what I feel is when you say that as much as the Chief Justice cannot advise how they make decisions, but when it starts or it stems from the top, and we feel that the top cannot protect the rest of the body, then each judge will be fighting for their own self. And you know, when the head of state will say that you're corrupt and I'll come for you, what does it mean? We have seen it during the Moi era, where judges were afraid, and during the Ringera purge, most of them were afraid because they were saying either you follow what the executive wanted or you face the door. They're human beings, they live with us, they walk with us, they work with us. It is our duty and our responsibility to ensure that they also feel safe, that when they give these decisions, that members of the bar, members of the public are standing strongly behind them. And that is the fear that we have. And I would say it doesn't even go far. If you look at what was happening in Tunisia, the president said just in 2022, it started in that tangent. The judiciary giving orders that were not favorable. Then he fired judges, 22 judges and prosecutors, believing that they are corrupt. The CJ has given orders and they have all been ignored. So this is not a fear of something that cannot happen. We have seen it happen just at the north, and this is a history. The reason we celebrate the 2010 Constitution is because these are fears that we never want to happen again. And so we say, if it's a tantrum, do not go to the child.
Okay.
Stand up to the child.
Absolutely. And perhaps as you...
As I respond now to my question in terms of what we're going to do.
Yes.
As president, my aim would be, how can we work better with our representatives at the Judicial Service Commission? We have 2 representatives, and this year we'll be choosing the male representative. Yes. What I hope is that we can have a better working relationship, that we will call on our Judicial Service Commissioners to answer to the members of the Law Society of Kenya. That when they feel their voices are drowned because they are the minority, we will stand up with them. We will raise our concerns with them. The question of corruption is something that is still near and dear to members of the Law Society of Kenya. So we want to fight the issue of corruption and ensure that any judicial officer that is corrupt is held to book. But at the same time, we'll expect our Judicial Service Commissioners not to walk and follow a tangent that will ensure we erode the importance of having a judiciary that is independent.
Absolutely. In just 1 minute before you sit down, so that we also hand over to the other participant, looking at this track of the barring of the senior counsel Ahmed Nasir Abdullahi to appear before the Supreme Court as president, as an aspirant of the presidential position, what will be your take moving forward?
My take, and I've made it quite clear, is that that process was wrong and it was unfair and it was arbitrary. What I say is that the Supreme Court of Kenya is a public office. As was said by Dr. Mutubwa, that they are also taking or benefiting from public coffers. So they also must expect to be held accountable the same way. I'm not saying that the individual, Ahmed Nasir, because he mentions he's not happy with what's happening at the Supreme Court, is perfect. But I'm saying it could be any member of the bar that today you wake up and you raise concerns and you talk about the decisions that are being made by any judicial officer, and a dangerous precedent has been made that we can ban you from attending those courts. So the question is, was there any process that was involved? Was even allowed an opportunity to be had? And they go even further to bar even any members of his office. What have they done wrong?
Absolutely.
That they should be held to also that same standard. I think what is fair is that if our Supreme Court can dish it, they should be able to take it as well.
Thank you very much, Madam Vice President. I'll now call upon Peter Wanyama to be able to raise the issues before we move to Xavier. Let's look at the administration of justice so far, and so far as you look at the rule of law. What do you aspire? Because this is you've never been an LSK leader before, I gather, and this is your first time, unlike your colleagues, your participants. When you look at what you project for those, for your tenure, should you be elected as LSK president, what will you do different, even looking at the barring of the senior counsel to appear before the Supreme Court?
Yeah, thank you very much. Just a quick reaction to Dr. Mtubwa first. I think I need to introduce Dr. Mtubwa to the history of our legal history properly. And there's a very interesting book that I want Dr. Mtubwa to read, The Strange Alchemy of Life and Law. How do judges decide cases? And there's something very, very interesting that happened in 1944 in the US. I think it's 1937, 1944 in the US. Same scenario with what is happening here, where the president in the US, Franklin Delano Roosevelt, was worried about what was happening at the Supreme Court in the US. There were four horsemen, four conservative judges who had a problem with this, every time striking down his decisions. And he threatened to appoint new judges to the court. Remember, under the US Constitution, you cannot have a limit. And that threat to appoint new judges to the court made the judiciary to recoil back and stopped nullifying decisions which were made by the executive in the New Deal program. So it is true that political power relations heavily influence judicial decision making. When judges decide cases, sometimes politics of the day affects how they decide cases. That is why the book by a South African judge, Jeffrey Sachs, on the strange alchemy of life and law, will give you an insight on sometimes what happens to the minds of a judge when they are deciding cases. And it is true, when the Chief Justice surrenders like that, it affects sometimes the decision making. And it might be speculation, yes, but it is actually true. As a practitioner, I have seen it. These judges can be cowed by decisions. And remember, we are doing it against the background of Moism, where a judge will be called by a special branch and they are told to make decisions. So and you know these things are made in secret. So the question is, really? So those issues are important. Myself, in terms of LSK, I'm seeking to run for LSK president. I've never served in any leadership position at LSK before, but we believe that we need to be more strategic, especially when you're engaging with such a president. I bring on board skills in terms of just strategy. As Law Society of Kenya, we need to be extremely strategic when you engage with an aggressive president. Two, we need to be strategic to protect the judiciary, because the judiciary is suffering from, to me, challenges of perception. Remember, the concerns which were raised by the president appear to be legitimate, concerns about corruption. So there are questions about perception, whether the judiciary is doing well in terms of service to Kenyans. But the mechanics of how those concerns were raised then raises fundamental questions which we in the Law Society of Kenya, if I take over the leadership, will be able to address. We need to have a system that functions well, a system that is able to protect the concerns raised by Kenyans. And to me, that calls for really a serious strategy. And engaging such a president, you have to be extremely strategic. Are you going to negotiate? Remember, Law Society of Kenya needs the executive. It needs the executive to pass policies and laws that promote legal practice.
To the point of the barring of the senior counsel?
The Supreme Court, in my view, they have raised concerns which are legitimate. Concerns which we think judges are fed up with the behavior of senior counsel. But do you go ahead and bar him from ever appearing in the Supreme Court? To me, that appears to be an overreach because the legal system has enough safeguards for judges to protect themselves. One, the judges can sue Admin Nasir for defamation. Two, they can cite him for contempt and send him to jail and order a fine that he pays a fine. So barring him from appearing in court and barring his associates raises questions about fairness. Yes. It raises questions about whether judges really care about the rule of law, because was Admin Nasir heard? What about his partners? What about his associates? Were they heard? Is this decision an overkill? So from where we stand as a bar, we think that the Supreme Court has made a decision which is an overkill, and they need to retract so that we really follow the rule of law. The Supreme Court is also bound by the Constitution of the Republic of Kenya.
Thank you very much, Sami. Over now to Xavier Akabi. You are vying for the position of Counsel of LSK. Yes, indeed. I would like to gather your views, especially on these two issues. First of all, as Counsel of LSK, your advice perhaps to the President of the LSK, of course as well to your representatives in the Judicial Service Commission, and your take on the barring of senior counsel to appear before the Supreme Court of the Republic of Kenya.
Yeah, thank you very much for that question. And the first thing that I'd want all of us to try and remember is the fact that not only were there concerns about the independence of the judiciary, but there is a statement or a suggestion that was made by the president and also other politicians that they are not going to follow, or they are not going to they are not going to respect judgments and orders that come from the courts. And that is what really scandalized the legal profession. And that is why we saw the kind of picketing. Because that in itself is bread and butter for advocates. The rule of law, number two, the rule of law, number three, it's the rule of law. And if we do not have the rule of law, then there is absolutely no need for there to be advocates in this country. In fact, I would dare say that the only welfare that advocates need in this country and anywhere else in the world is the rule of law. And that is how we get our bread and butter. So my advice to the president would be that he must respect, and he cannot be seen to say or to suggest that he is not going to follow orders that come from the court. That is completely unacceptable. And one of the things that we shall be pushing for, if elected, is precisely that: protecting the practice space of advocates by enforcing the rule of law. And if I can go back and speak about this issue with Admin Nasir, there is a concept which is usually called the independence of the bar. And the bar is usually independent from the legislature, the executive, but also the judiciary. So that when the judiciary is doing something wrong, we are going to call them out. And that is precisely what we have done. 1 week, we are fighting, we are picketing for the judiciary to protect the independence of the judiciary. And the next week, we are condemning the highest court of this country for what they have done to senior counsel Admin Nasir. Because there was absolutely no procedure that was followed, arbitrariness, which, like I said earlier, it is a Supreme Court which comprises of justices who ought to know better. That was completely unacceptable of them, and they should come out and actually apologize. Apologize to the public for what they did. But that said and done, we also need, and this really goes to the Chief Justice, because the executive is casting aspersions, is making suggestions about something called corruption in the judiciary. And it has become a very big secret that there is corruption in the judiciary. How is the Chief Justice, as the head of that arm of government, going to address corruption in the judiciary? She must address it. Corruption in the judiciary should not be looked at in such a way that, no, you are attacking the judiciary. There is corruption in the judiciary, and it must be addressed.
Absolutely.
One way or another.
Thank you so much, Xavier. I can see your colleagues, the Vice President, as well as Sami, nodding their heads. We shall be coming back to them, but I want to hand over to the Honorable Judge for the session tonight to be able to, of course, be able to pick opinions from the legal experts that we have here in studio from Linda.
Absolutely. Linda, you have the audience behind you.
Right.
They've been paying attention. They've been watching and listening and making notes. And I'm sure they've got questions. Over to you.
Mungare here has written like a whole book already. I don't know what we'll tackle, what we will not. But even before we get to Mungare, there is Nelly Thuo who is watching. And she says, my family has been in a situation where tumenyimwa haki yetu na kupewa ambaye hana haki, to a point where our lawyer is called aside by the other side. In fact, sina imani na judiciary na lawyers, although all are bad, but 99.9 are bad. I am for dialogue. I do not know. Well, that's her response, and basically the people who are watching at home, it's very important that we also get their view, that we could be pointing a finger, yet within ourselves there is a big problem. Mungare, you want to say something?
A lot of things.
A lot of things. Please do not say a lot of things because of time, yeah? So he could stand?
Yeah.
Bojo, is that okay? That is fine. Yes, the audience too is part of the show, so... Yeah.
Thank you. I'll try and be brief in a lot of things that I've had from the panel.
Mungare, I can only give you less than a minute.
Thank you.
Proceed.
Number one, the only characterization of the president's sentiments are the tears of a jilted lover. My professor here, Dr. Mutubu, I hope it won't go to my disciplinary record. I hope to disagree with you. When the French philosopher Byron...
Proceed with caution.
When Byron de Montesquieu coined separation of powers, he gave us two parameters and metric. One is functional separation and two, institutional separation. That one function will not overreach or override to the other arm, and a person from one arm will not do the job of the other person. Now, our constitution does not at all fathom a point whereby the president and the chief justice will meet. I'll give you these scenarios. Let's look at three officers who had the arms of government. Do we vote for the speaker? No, we don't. It's a political office that members of parliament will vote for. We vote for the president. He campaigns and he gets all that. Do we vote for the chief justice? No, we don't, because we give this power to the Judicial Service Commission, and therefore it is an office that is protected. Now, to another thing, before I sit down, let's look at the president of handshakes in Kenya. Number one, Uhuru plus Raila. What did it give us? BBI. Ruto plus Raila. What did it give us? NADCO. From the president, I don't want to anticipate what Martha Koome and Ruto will give us. Wow. Now, let me also speak on something of capture of the judiciary. The 2010 Constitution anticipated, and from the history that we've had previously, number one is fiscal capture. The legislature has not operationalized the judiciary fund. Now we won't be having a problem with the judiciary. Two, employment. Tenure of judges. The Constitution protects judges that they'll work up to 70 years. So the president cannot touch that. Three is removal. Removal of a judge will have to go through the Judicial Service Commission, Suomotu, or through what Sonko did. So if Rigathi Gachagua and other people have anything to say about judges, we have procedures. Now as I sit down on the Ahmed Nasir issue, Section 56 of the Advocates Act gives judges power to deal with errant advocates. But the LSK, on your part, you failed. Let's have regulations on what judges can do, what cannot do. In my opinion, that was an overreach by the Apex Court of Kenya, behaving like the executive. Now, as I sit down, I have these statements to make. The judiciary and the executive cannot meet and hide in the essence of corruption. When the mother hyena wants to eat her babies, she accuses them of smelling like goats. And it matters not whether you carve Caesar as a dish fit for the goats.
That's enough. Young man, thank you very much. Thank you.
Mercy, briefly, before we go back to Daktari as well as Dong.
Thank you. We can see the future of the country.
Right, briefly,
right,
Mercy.
Please.
Okay.
My question will be directed to the madam there. So in light of Ahmed Nasir's case, she has talked about how she's planning to eliminate corruption in the country and all that. So I'm planning to know if she was the president in such a situation, what could she have done differently? Yeah, that's all I need to know from her.
All right, thank you. She will have the right to respond as well as Daktari later on.
But one more question.
One more question. If there is a question, yes, on this other end.
There's a gentleman right behind.
Right. Start by telling us your name.
Thank you. My name is Albert Ombongi, and first I want to appreciate Faith for mentioning the Trojan story between the Greeks and the Troy. But onto the question, what we need to understand this evening here today is, when did the executive realize that the judiciary is corrupt? That is the question which we need to answer. And if you answer that question, we will be done with this debate. If I hold her hand, she says don't touch. If I hold her foot, she says don't touch. But when I hold her waist bead, she pretends not to know. Those are not my words, but the words by the greatest writer from Africa, Chinua Achebe, in his book Things Fall Apart. As I finish, if today I decide to start a project from my home county, Kisii County, a project benefiting 100,000 people from my county, and one person, Makori, moves to court and challenges the constitutionality of my project, and the court decides I should stop my project because it is unconstitutional, because it discriminates against other people in my county, what will I do? I will stop the project. But if the courts have decided that the housing levy, or rather the housing tax, it started as a contribution, it later matured to a levy, and then now we are being told is a tax. What should the president do? Unto the constitutional lawyers, the powers which are provided under Article 1, Sub-Article 1, the sovereign powers belongs to the people. As a person, as a common mwananchi, Albert Ombongi, I have the powers to start my project to benefit the people of Kenya. But under Article 1, Sub-Article 3, the president operates under delegated powers. Then the question is, who is more powerful, or is the president above the law? Thank you.
All right. Thank you, Albert. If you proceed, we will tax you for taking our time. But thank you for your questions. I believe these questions should be addressed before we proceed.
Before we proceed to Evans, briefly.
Yes.
Yeah.
I think let me start by saying you can see how brilliant our students are. And this tells you that we are doing a good job here. And you can challenge your professor without consequences. That is the beauty of our democracy, that you can challenge the president, you can challenge the Chief Justice's pronunciations. But I want to say two things. You see, let me begin by saying that what is good for the goose is good for the gander. That's what the English say. When Chief Justice Maraga told us he is seeking an appointment with the president and he can't get it, he wants to talk to the president to address the question of funding the judiciary and other problems, including the hiring of judges. What was said? He was told that, look, you cannot get an appointment to speak to us. That time, I did not see lawyers or anybody go to the street and ask, why is Chief Justice Maraga asking to speak to the president? Today, because there is now a discussion, there is suspicion, there is a backdrop, there is a basis, there is a fear, there is a founded. And I want to agree with my friend Peter that sometimes when you have constitutional architecture of a constitution like the American one, where you have the president appointing judges of the Supreme Court, it is not possible here because we have mechanisms. Coming from that history, we have known that we cannot allow one man that latitude to appoint for us judges of the highest court or superior courts. But lastly, let me say something about the the issue of Senior Counsel Ahmed Nasir Abdullahi. Now, Senior Counsel is not an advocate by tokenism or by some gift of anybody. He has earned his place, and he has earned the place to be advocate and senior counsel. Now, when you bar him from going to court, and you bar him on the basis of certain conduct, however abhorrent the conduct, one question that comes to mind is, what can we do about it? Because it has already happened, and I've seen the Supreme Court today attempted to refashion the order by saying they will recuse themselves in all matters. So they are no longer saying that we are barring completely, we are saying that it is our decision not to hear him as an individual decision of the judges in their collective. But the question to the Law Society is this. The Law Society is also a trade union for lawyers. And you expect that at this stage, a publicly spirited president or presidential aspirant would have moved to that court to plead Ahmed Nasir's case. Just the way court would, just the way the other unions would. Attend as amicus, go to court and say, we are here under Section 4 of the Act, the LSK Act, and we want to make our representations on this question. And I'm not running for any office, but that is what I would have done. Even more importantly, one would have expected, for instance, that our president of the Law Society, perhaps the council, would have asked or sought mediation between these two and said, what is exactly the issue between Ahmed Nasir? Is it conduct unbecoming? Because even in disciplinary proceedings against counsel, there is a provision for alternative dispute resolution and mediation. Perhaps this tension between Ahmed Nasir and the court would have been resolved or told by having that session. So I want to say that there must be a specific answer by aspirants on what they are going to do. Not just to say we will be strategic, we will be creative, we will be. You must tell us, what is that creativity? You know, when you mark a student's script and he is all over about strategy and arguments without telling you specifics, that is a student who has no answer. So the point here is, I expect that at this stage of the campaign there are specifics. You have had questions that are very specifically pointed about certain things. Right. But at the end of the day, the ecosystem that is our legal system exists because lawyers and the bar have a good relationship with the bench, and there is absolutely nothing wrong with the bench having a good relationship with the executive. But remember that you must have a relationship, but it is guarded. You must ring fence there. And I've had my good students saying that the Constitution does not anticipate that the judiciary will meet with the executive. The State of the Judiciary Address is a meeting of those two organs. It is not just a rosy place where people come and clap and drink soda. No, it is a place where people discuss deeply the problems that afflict the common person. And you have just heard one of your viewers saying that some people feel very strongly that sometimes they don't have justice. And being a judicial officer, just like being a lawyer, is a very difficult job, because sometimes you are doomed whether you do it or not. Down when you do it, down when you don't do it. Sometimes you just have to leave because it is a double-edged sword. But the point I'm making is, as an individual, I know that our society has made our position known, but as a member of the society, we also are entitled to hold personal views, including disagreeing or ameliorating or varying the position of the society. So I hope tomorrow my good president, vice president and council member will deliberate the possibility of intervening on behalf of senior counsel Ahmed Nasir while restoring the dignity of the Supreme Court by addressing the Supreme Court's concerns.
All right.
Thank you.
So, Madam Vice President, if I am to give you time, it will be less than a minute, so that we also be fair to these two gentlemen who are waiting here to respond to Mercy. You could go up, yes, and respond to her. Or perhaps just speak the microphone from here. Okay.
So I actually have two questions. So can you give me 2 minutes to respond to Dr. and Mercy as well?
We'll make it 1.5.
Okay. So Mercy, as the head of state, what I'll do is go back to the drawing board. He has a good project that he wants to do, but the question is, what about the effect? there are so many people who will contribute to that fund, but will never benefit from it. Look at the reality of the country that we live in. Even the so-called middle class cannot afford their own homes. So when you're telling them to contribute to a fund, or you tax them on a fund, that they will never own a house, to buy someone else a house, is it fair? That is the question. And I think the head of state just needs to sit back. He has quite a battery of lawyers. He has a battery of advisors. And with that endeavor, I think when they sit together, they can come up with a different plan. How do they work to ensure that it's a fair process and it's something that even those who contribute could possibly benefit and have a home? Now, to the second question with regards to what tangible thing to do between Senior Counsel Ahmed Nasir and the Supreme Court, I think it was very clear the President also mentioned that he spoke as well to Ahmed Nasir. And if you saw, Ahmed Nasir has also made his position. I would do mediation. But the challenge right now is I would allow parties to simmer down. The Supreme Court is on a high note. Ahmed Nasir is on a high note as well. And you must remember, Senior Counsel Ahmed Nasir, even the rules on how you deal with the Senior Counsel are different. And the chair of the Senior Counsel bar as well would have to be part and parcel of that process. So that's what I'll do, a bit more of mediation. And right now the position is let the headlines simmer down before you can try a mediation process with the parties. That would be my direct answer to you.
Fair enough. Evans, no.
Okay, thank you so much, Linda. I think I would respond very quickly to her question. And on this one, I want to disagree with him in a very fundamental way. We are not saying there is a problem with dialogue. For institutional committee, in fact, the Constitution itself encourages cooperation. What we are saying is that don't go to State House and come back and tell us what we already know. And on this one, I would disagree with Mwalimu here, Dr. Mutubwa, because what is called dialogue that was between President Ruto and the Chief Justice is already what the National Committee of Administrative Justice does. If the President has tangible issues around corruption, he has two forums. He can go to that committee and present his views, or he can go through the provision of JSC. And that has to come out so clearly. On the project, I want to say that each regime has a silver bullet project. You know, Moi had the Nyayo ya Moi, and Kibaki had the free education. Uhuru Kenyatta had the Big Four agenda, majorly technology and all these things. For President Ruto, his main agenda is housing. We did not hear the president talk about corruption in the judiciary until the housing levy was struck down. So our concern is the timing. We don't trust politicians. We have had a history. And I want to agree. With my learned friend, Mr. Peter, and Madam Faith. And I would also refer Mwalimu. Today, people are making reference. I will also give him a material. Professor Haron Barak writes, a judge in a democracy, the role of a Supreme Court in a democracy. The issue of corruption in the judiciary and how politicians, react to it is not a question of only reality. It's also a question of how the general public perceive. It's also a perception question, which you have to deal with. If you look at how Kenyans are reacting right now, they are saying, although Maraga was denied, an audience between President Uhuru and himself, he was on the stairs of the Supreme Court and calling out, President Uhuru Kenyatta. And we are not saying that, the Chief Justice throughout should behave as a judge. Is the president of that court, which of course is a different administrative, an administrative role. So we are saying that the Chief Justice, as long as he's supposed to, balance between aggression and diplomacy, he must not encroach the law in the essence of saying we want to be diplomatic with the head of state.
Right.
Because we have that history.
Okay.
Even when things were bad during Moi's time, even when things were bad during Kenyatta's time, the likes of Chief Justice Madan stood the test of time.
I wanted to advance the agenda further, and I hope that Francis Wanjiku, your question was answered, especially in the question of LSK, and how then they will come in to address this matter that we discussed this evening. Do you suppose your question was well answered? Do they confidently tell you that they're capable of handling this?
What we can...
Is it on?
Yes, it's on.
Okay.
What we can hope and pray is that, even for the law students, is that the gentleman here, Peter Wanyama and Faith, is that they will remain strong and they'll remain firm, and we'll pray for them. And when they need our counsel as members of the Law Society, we will be available. But one of the things that I wanted to touch on is when, I think one of the students asked is, when did President Ruto realize that the judiciary was corrupt? If you go back to your news clips a few weeks ago, you saw the Aurora and Kimwarer case being dropped like a shell, where the ODPP placed witnesses who are, let's say, friends of the president, and they did not cross-examine the witness, they just dropped the case. So the question is, why hasn't the president said that the ODPP is corrupt? The second part is Parliament. Parliament has been on recess since the 30th of November. But suddenly, we have seen the gentleman, the honorable chair of that committee, discussing the housing levy, gentleman for MP for Molo, Kuria Kimani. Suddenly, they have arose from the dead. Right now, they are active. They are doing public participation. So the question is, if they could not discuss other matters in Parliament that are of public nature, how comes, what is it that about this housing levy bill that has made Parliament get out of their Christmas recess to come back? Because officially, Parliament ought to open on 1st February. So these gentlemen should be at home, but they are busy working. So one of the things I want to encourage law students today is that the role of the law society is one of the most important roles in this country. And if you look at your other, you have friends studying other courses. You look at accountants, which is the ISPAC. You have engineers, the engineering society. Have you heard any of them mention anything to do with the rule of law, destroying of the democracy in Kenya? None. It's because the society depends on lawyers like Peter and Faith. So at the end of the day, remember that even one day you'll become president, maybe after 15 years of being admitted. But at the end of the day, what is important is that let us not underestimate the power of the law society, because it is what is holding between the president and his takeover on the judiciary. Thank you.
All right, fair enough. And we want to take it back to the judge. The judge, we realize that then the Law Society of Kenya has quite a humongous role in addressing some of these concerns and perhaps bettering the justice system in the country. I will take it back to you so that then we can as well get to engage the contestants or perhaps the aspirants or the candidates who are the main individuals of the day.
Right. Now, we have two situations that we have to be alive to. One is that we've completely run out of time, and it's important that we respect the time that we have. And second is that with the little grace that we've got, we only have time for a round of parting shots. And so I'd like to give this opportunity to the people that are looking for opportunities to serve. So all the candidates, I'd like you to prepare strictly, and I'll be counting, strictly 1 minute submissions, 1 minute each for a parting shot that will be going all the way out to the nation of Kenya, to your colleagues, to the people that you're inspiring. 1 minute each. And without further ado, let's start with the gentleman at the far end, Mr. Xavier Ahabi. The stage is yours, and your clock starts now.
So my name is Chrysostom Xavier Ahavi. I'm vying for the position of General Member Representative in the Law Society of Kenya. The Law Society of Kenya is the body that is protecting and defending the rule of law in Kenya. And I would urge any advocate out there to look at the candidates who you are voting for and to vote for candidates who are steadfast, who represent progress, and who are going to transform this society into something that we are all Kenyans are proud of. I represent progress. I represent practicing forward. So let's please vote for me on 29th of February 2024. And thank you very much. God bless you.
Right. Well done. Well done. Good use of time. Mrs. Odhiambo, please. The stage is yours. And your time starts now.
Today, the Law Society stands at the divide of who will hold your hand, who will stand for you, who will fight for you. The judiciary is at a crossroad. We see the challenges of what is happening in the executive and parliament. Are we going to let the last wall that we hold dear as advocates finally fall to the executive? I'm asking you to have faith in faith. Stand with me. Let's walk together this journey. The Law Society is our home. The people of Kenya are our country, our love, our hearts. Let us not lose them to any arbitrary nature of the executive. I ask that we work together, we walk together. Let us hold the Law Society high, and I will remain true to the oath that I took as an advocate. I will uphold the rule of law. I will stand for justice. I will stand for you as advocates, and I will stand for each member of the public and the nation. Vote for faith.
Time's up. Thank you very much. Mr. Wanyama. And
thank you very much.
Time starts now.
Yeah, thank you very much. First of all, it's important to mention that I was banned by the Supreme Court in 2016, but I apologized and the matter was settled. My name is Peter Wanyama. I'm vying for Law Society of Kenya President. I am the voice that the people of Kenya want to hear. I'll be consequential. I'll be pushy. I'll be also strategic. I am using the three words deliberately because as Law Society of Kenya, we also need the executive. We need parliament. There are critical aspects of practice that we need legislation to protect our practice. At the same time, we must ensure that we hold that government to account. So that calls for strategic leadership. We can't be in an environment where we are continuously fighting because we need each other as brothers and sisters. Law Society of Kenya has a mandate under the provisions of the Law Society of Kenya Act, Section 4, which will lead Kenyans in terms of just ensuring that we are able to be strategic about those functions.
Time's up. Being very strategic. Now, as we wind up, the three remaining guests, I'm afraid we will only give you 30.
This can happen again and soon.
All right. Thank you very much. Very good use of time. Next, over to you. 30 seconds starts now.
I'll just like to tell the law students, when you're thinking about the Amenasir matter, stop thinking about the procedure. Look at it as if what will be the right punishment for that lawyer. Thank you.
Very well said, very well said. Before we finish with our host, the young man at the corner has something to say. Real quick, you have 15 seconds. Go.
Thank you very much. I'm afraid the time was so short, but I'll just mention one thing in regards to the relationship between the executive and the judiciary. They're secret meetings. Remember, if you tickle a madman in the dark, he will come and tickle you during the daylight. Whose embarrassment will be? Thank you.
All right, very well said. 15 seconds. The young man right behind you, 15 seconds. That's all we've got. That's all we've got. Mr. Nzao, I believe. Time starts now.
Okay, thank you. So, my name is Zhao, as stated. So my question is on regards to the statements, or rather the actions by the judiciary, the Supreme Court in regards to Ahmed Nasir. So Article 160 of the Constitution of Kenya.
Brother, I'm sorry, we have run out of time. You had 15 seconds. Your time is
just
over.
Finish it up.
Your time is over. I'm sorry. We have to respect the rule of time. And finally, our host, 30 seconds.
I want to say this is a great night for our university, our school, because this is the first time we are hosting such an important event. I just want to wish the candidates the very best. Mount Kenya University School of Law doors are open for you. We want to see you more coming, not just during the campaign. Come and tell us about what you have for the young people, the young generation, that these are the future presidents, and this has been inspiring. I just want to finish by saying that quoting that somebody said that the day we stop talking is the day we start fighting. Dialogue is good, discussion is good, because that is what we are doing today.
All right. And with that, we're out. George?
Absolutely. And if we take this chance right here at TV 47, the People's Court, to thank you so much for joining us. Tonight we've had several candidates. Peter Wanyama, an advocate of the Higher Court of Kenya. We've also had Faith Othiambo, Vice President, LSK. The two are vying for President of the Law Society of Kenya. Xavier Akabi vying for the Council Member of the Law Society of Kenya. Ladies and gentlemen, thank you so much for joining us. Dong Evans, thank you so much as well for joining us tonight. Francis Wenjiku Mwijaku, as well as Dr. Alfred Mutubwa, expert, as well as Dean of the School of Law right here at Mount Kenya University Law Campus. My name is George Maringa. We thank you for your tremendous feedback. Unfortunately, that's all we had time for right here on TV 47. As always, stay safe and be kind to one another. The conversation continues. I'll see you next time.
Well, what surprises me is that none of the students have spoken about what they would wish for the Law Society of Kenya to advance in relation to education. They behave as though they're already in the bar. So, well and good. We close it at this very point. Thank you so much for keeping us company and for the immense feedback. We look forward to see you again next Tuesday. My name is Linda Alela.
All right, and all rise. I would like to declare the court is in recess. Good night and God bless you.
God bless. Thank you.
All right.